This case did not collapse in a courtroom. It stopped in a filing. No jury was seated. No opening statements were delivered. No witness ever took the stand to defend or challenge the evidence gathered inside Mar-a-Lago. Instead, the classified documents prosecution ended with a motion to dismiss after the Supreme Court's ruling on presidential immunity. And that procedural ending created a different kind of tension, one that is still unfolding. To understand where this stands now, you have to go back to August 8, 2022. That was the day federal agents executed a search warrant at Mar-a-Lago. The inventory later filed in court listed more than 100 documents marked classified, including materials labeled top secret and sensitive compartmented information. The affidavit supporting that warrant described probable cause to believe national defense information had been retained unlawfully. That search led to a 37-count indictment. The charges included alleged violations of the Espionage Act, specifically 18 U.S.C. Section 793E, along with conspiracy and obstruction-related counts. Prosecutors alleged that after a grand jury subpoena demanded the return of classified materials, boxes were moved. The superseding indictment later expanded on those obstruction allegations, claiming efforts to conceal documents from investigators and mislead federal authorities about what remained on the property. Those allegations were serious. Obstruction counts often carry greater practical exposure than the underlying retention charges because they speak to intent. But the case never reached trial. When the Supreme Court clarified limits on prosecuting a sitting president, the Justice Department moved to dismiss. The motion was procedural, not factual. It did not withdraw the allegations. It did not concede evidentiary weakness. It relied on constitutional doctrine. The indictment disappeared from the active docket, and that is where most public coverage stopped. What did not stop was the special counsel's obligation to complete a final report. Under federal regulations governing special counsels, a closing report must be submitted to the Attorney General explaining prosecutorial decisions. That report was completed. It was divided into 2 volumes. Volume 1 addressed the election interference investigation, and portions of it were released. Volume 2 addressed the classified documents case. Volume 2 remains sealed. That sealed report is now the focal point of a new legal confrontation. Multiple advocacy organizations have filed motions seeking public release of the documents volume. Their argument is straightforward. The prosecution was halted by constitutional immunity, not by evidentiary failure. Therefore, the public has a legitimate interest in understanding what the investigation concluded. They argue transparency promotes accountability. The Justice Department has resisted full disclosure. Its position, reflected in court filings, emphasizes institutional considerations. Releasing detailed prosecutorial conclusions without a trial, the department argues, risks prejudicing future proceedings and undermining fairness principles. There are also concerns involving classified information and grand jury secrecy. This is not speculation. These are arguments appearing in real filings. The courtroom drama did not move to a jury box. It moved to appellate briefing. The legal question now is no longer whether documents were recovered at Mar-a-Lago. That fact was established through warrant returns and indictment allegations. The question is whether the special counsel's untested conclusions should enter the public domain. Why does that matter? Because obstruction charges hinge on intent. The superseding indictment alleged that boxes were moved after a subpoena. It alleged that false certifications were provided. It alleged concealment. Those claims were never cross-examined in open court. They were never weighed by a jury. If Volume 2 contains detailed accounts of witness interviews, internal communications, or prosecutorial assessments of credibility, those findings could shape historical understanding of what happened inside the residence during that period. There is a structural tension here. On one side is the principle that individuals deserve the presumption of innocence and the right to confront evidence at trial before conclusions are publicly cemented. On the other side is the argument that when a case is halted by constitutional doctrine rather than factual insufficiency, suppressing the investigative record leaves the public with unanswered questions. Courts will have to decide how to balance those interests. This is the phase I am watching closely. First, standing. Do outside organizations have the right to intervene and demand disclosure? That threshold question could determine whether the case even proceeds to substantive review. Second, scope. Even if release is ordered, will it be partial, heavily redacted, summarized instead of fully disclosed? Third, classification review. Portions of the report likely reference materials that remain sensitive. Any disclosure process would require layered clearance decisions. Fourth, precedent. However this resolves will influence how future special counsels handle investigations involving high-ranking officials. The public often assumes that when an indictment disappears, the story ends. In federal practice, it rarely does. A dismissal based on constitutional immunity does not erase the investigative record. It shifts the battleground. Instead of evidence being tested before 12 jurors, it becomes the subject of motions, privilege assertions, and institutional negotiation. The absence of a verdict creates ambiguity. Ambiguity creates pressure. And pressure, in high-profile federal cases, rarely fades quietly. Because somewhere inside a sealed volume is the government's final theory of intent, concealment, and decision-making. And no one outside a narrow circle has read it. That silence is not closure. It is tension waiting for a ruling. The transparency fight over Volume 2 is not a political spectacle. It is a procedural chess match. At the center of that match is a basic but powerful question. When a prosecution is halted for constitutional reasons, does the investigative narrative remain buried, or does it enter the public record? Federal courts approach that question cautiously. Grand jury materials are protected under Rule 6E. Classified information is governed by statutory and executive controls. Prosecutorial memoranda traditionally remain internal. The Justice Department argues that releasing detailed charging rationales outside the adversarial trial process risks unfair reputational harm. But transparency advocates counter with another principle. They argue that the special counsel regulations exist precisely because certain investigations involve extraordinary public interest. If the prosecution cannot proceed to verdict, the report becomes the only comprehensive explanation of what the government believed it could prove. This is not about relitigating the indictment. It is about defining institutional memory. Remember what the superseding indictment alleged. It described efforts to move boxes after a subpoena was issued. It referenced surveillance footage. It identified specific counts tied to alleged concealment. Those allegations were structured to establish willfulness and intent, not mere accidental retention. Intent is the dividing line in obstruction cases. If Volume 2 elaborates on how prosecutors evaluated evidence of intent, whether through testimony, documents, or digital records, its contents could either reinforce or complicate public understanding of the case. And that is precisely why the release question matters. Because once published, even in redacted form, those conclusions become part of the historical archive. They influence academic analysis. They shape congressional oversight. They inform future legal scholarship on executive power and records retention. Courts are not blind to those implications. Judges must weigh fairness to the individual against systemic transparency. They must consider whether redactions can adequately protect sensitive information. They must determine whether the public interest outweighs potential prejudice. There is also timing. Appellate review takes months. Classification reviews take longer. Each delay extends the period of uncertainty. Each extension deepens the sense that something consequential remains unseen. From a legal strategy perspective, the Justice Department's resistance is not surprising. Prosecutors are trained to speak in court, not through reports that cannot be challenged. Their institutional instinct favors the adversarial process. But when that process is interrupted, the report becomes the substitute. And substitutes are imperfect. If the court orders release, expect layers. Heavily redacted sections, executive summaries, possibly judicial commentary explaining what cannot be disclosed. That layered disclosure could generate additional litigation as parties challenge the scope of redactions. If the court denies release, the sealed volume does not disappear. It remains in government custody. It becomes a document future administrations could revisit. It remains a potential subject of congressional subpoena. In other words, dismissal did not eliminate leverage. It deferred it. There is a broader constitutional dimension as well. The Supreme Court's ruling on presidential immunity created boundaries for criminal prosecution. But it did not address the transparency obligations of the executive branch after a halted investigation. That gap leaves space for judicial interpretation. How courts resolve this may define future expectations for how investigations of high-ranking officials conclude when trial is impossible. I am watching for 4 specific signals. First, whether the court grants intervention rights to outside groups. Without standing, the case ends procedurally. Second, how the court frames the public interest analysis. The language used in that ruling will signal whether transparency is viewed as exceptional or presumptive in this context. Third, whether classification review becomes the dominant barrier. If national security concerns are cited broadly, redactions could be extensive. Fourth, whether Congress attempts parallel access through oversight authority. That could create interbranch tension independent of the judiciary. This is not cinematic, it is methodical. But methodical federal litigation can reshape institutional norms quietly and permanently. The classified documents indictment once centered on boxes, markings, and alleged movement after a subpoena. Now the focal point is a sealed report and competing interpretations of accountability. There was no second search warrant. There was no dramatic courtroom confession. There is instead a procedural standoff. And in federal practice, standoffs often outlast indictments. The outcome will not determine prison sentences. It will determine narrative authority. Who gets to define what the investigation ultimately concluded? The absence of a trial left that question unanswered. The transparency fight may answer it. Whether through release, redaction, or continued sealing, the court's decision will become the final chapter of this phase. And final chapters in federal cases are rarely about spectacle. They are about precedent. Tell me if you want the next breakdown to focus on the appellate strategy, the classification review process, or the long-term implications for future special counsel investigations.